All right, let's talk about the final two exclusive rights, the right of public performance and the right to display. Under 17 U.S.C. 106 subsection 4, the public performance right applies to literary, so plays, books, short stories, letters, emails, etc., etc. Musical, so musical composition, so lyrics and the music that goes along with that, dramatic and choreographic works, pantomimes, and motion pictures and other audiovisual works are all covered under public performance. What is not covered? Architectural, pictorial, graphic, or sculptural works. So our photographs, our paintings, posters, sculptures, and such do not apply to the public performance right. We'll see those under display. Sound recordings is very limited for public performance. The performance right is limited to public performances via digital audio transmissions. We will talk more. I'll give you some more examples with these and how that plays a role. So what does this mean to perform? What does it mean to perform? To recite, render, play, dance, act it out, either directly or by means of any device or process, or in the case of a motion picture, to show its images in any sequence of, to make these sounds that go along with it audible. So, singing your favorite song in the shower. Before we get to that question, let's do some examples that would fall under what does it mean to perform? Play a CD of music, to watch TV, to have the radio on. Those are all examples of performing. Reading a letter out loud in public, reading your short story at a coffee shop open mic. This only applies to the public. So, can you sing your favorite song in the shower? Can you sing it to your family? Christmas, everyone gets together, holiday times, singing songs. Maybe not Christmas songs, because a lot of Christmas songs actually are in the public domain, as we just talked about. But you can do that. Singing in the car with your friends. You can do that without infringing. What does publicly mean? It means one of two things. Perform or display at a place that is open to the public, or where there is a substantial number of people outside your circle of family and friends. So the college hallway, right? Live concerts, bars, or transmit the performance to a place specified above, or to the public by means of a device. So you might not be doing it live, but you're transmitting it in somewhere. You're streaming it in from your bedroom to a public place. You're transmitting it through speakers throughout the college campus. Sound recordings, again, limited to digital audio transmissions. With a song, we have a writer, and we have the one who wrote the musical composition and the lyrics, and we have the person or company that owns the recording. Usually it's a record label, but it could be the same people, same owners, the owner and the writer. But generally you have, in a music setting, you have the recording artist who maybe wrote the song, and then you have the song recording. So a performance of a sound recording that involves no transmission or that uses analog format does not infringe. Examples of infringing: online streaming, internet radio, satellite radio, digital transmission. Okay, so a business playing a CD of music on a stereo, or a radio station that's playing music over an analog radio transmission, does not infringe on the sound recording copyright. They are both public performances, and one is not a transmission and the other is not digital. It's a radio station. Suppose Little Music Company holds the copyright in the musical work, Just Another Song. And Little Music released a recording of that song in 1995, and it is still often played on the radio. Various bands perform the song live. Bars and other businesses often play the recording over their sound systems. Are all of these performances subject to Little Music's copyright? The answer is yes. What is the copyright? Public performance. What's the type of work we have going on here? So let's walk through it. Suppose Little Music Company holds the copyright in the musical work, Just Another Song, meaning they wrote the song. They wrote the song, they own the lyrics and the music. Little Music released a recording of the song in 1995. So we're going to say Little Music Company also owns that sound recording. And it is still often played on the radio. And then we have various bands performing the song live. And then we have bars and other businesses often play the recording over their sound system. Okay, so we have a couple different rights going on here. For the enforcing the right and being challenged, we have to locate everybody and potentially reach agreements because everybody is infringing in this case. So what is it? What's in place for Little Music Company? You may have heard of these rights organization, collective rights organization, ASCAP, BMI. Radio pays for these licensing fees, ASCAP, BMI, that allows them to play songs over the radio. Bars and other businesses generally are required to pay ASCAP and BMI fees. Well, they try and hunt down these bars, and I know bars in Plattsburgh who's gotten these letters from ASCAP and BMI with regards to paying licensing fee. Now, these licensing fees are not for the sound recording. They are for the musical composition component. Little Music and their recording song can only collect fees if it's digitally transmitted. So we're talking about the underlying musical composition. Now let's talk about the various bands performing live. Maybe it's a cover band. Guess what? They have to pay licensing fees too. Generally they don't. But what happens is bars that normally have live acts come in and cover bands, they'll usually have a blanket license with these licensing agencies. So that's a general overview of how those work, those collective rights, but they apply to the performance rights. Those are the ones who are doing the collecting. Public display. 17 U.S.C. 106 subsection 5 gives us the right to display works, the exclusive right to display works, the copyright holder, and it applies to everybody, sort of, okay? Still applies to literary, musical, dramatic, choreographic works, pantomimes, but it also includes pictorial, graphic, and sculpture works, including the individual images of a motion picture or other audiovisual work. What it does not apply to is sound recordings or architectural works or other audiovisual works, okay? It's limited in individual images. So let's define display. To show a copy, either directly or by means of a film, slide, TV image, or any other device or process, or in the case of a motion picture or other audiovisual work, to show individual images non-sequential. So not going in order. And this goes well beyond putting a copy of a work on exhibit. Like what would be an example of a work being on exhibit? A painting, right? Poster, a sculpture, photos, go to a photo gallery, putting them on display. So we are going well beyond that. So here's an example of going beyond that. You're wearing a t-shirt and you have like the Superman logo on it, or you have you've taken an image from somebody's photograph. You took a photograph, you liked it, you think that'd work on a t-shirt, and you put it on a t-shirt, and then you're selling t-shirts, and you're wearing t-shirts. You don't even have to, now when you're selling them, you're distributing them, right? So we have the violation of distributing the work on top of it if you're selling it. But just putting it on your t-shirt and wearing it around, that is a display. Projecting an image of the work, and it applies to the public. So maybe you put your favorite photograph that is somebody else's photo you didn't get permission to on a t-shirt, but you only wear that t-shirt at night and in your house to go to bed, then maybe you do not have an infringement. It only applies to the public. So it's the same definitions. Public is the same definition as the one we had for performance. Open to the public, more than just family and friends. Or if the work is transmitted to such locations, any location that's public, regardless of the message received. So you're putting images out there. Maybe you're transmitting them, I don't know, into the sky in public where everyone can see them, like the Batman symbol. So, display. You might think, hey, I bought this picture. This picture is mine. This painting is mine. And then you have it transformed into, I don't know, flags, and you strap it around your car. What if you painted it on your car and drove around with it? That could be very much a display. I know it sounds small and kind of ridiculous a little, but it's still a violation of the copywriter's exclusive right. Now, when we talk about infringement, there might be a defense, fair use. The question is going to be how are you using it? But what we're talking about here is we're showing examples of what constitutes an exclusive right and what it means to potentially violate that exclusive right. But there's always more to the story, and we'll talk about that when we get to infringement. Here's a question. A website that allows users to browse pictures. You ever cruise the internet and you see images up on Google? You can click on images and boom, there's all these images that are all over. Is Google displaying photos? Is Google have a license to do all that? Because technically what happens is these are like search engines, right? The search engine, you search for a term and it shows you all the hits. It's not necessarily Google's pages. They show you all the hits, and then they have a section for videos. They have sections for images. Is displaying those browser pictures a violation of public display rights? There was one case that the federal courts have reviewed on that issue, but none of them seem to address the issue of whether or not that is a violation of display rights. It usually comes up, but what happens is the determination is whether that display is a fair use. So we will revisit our cases with regards to this display issue and whether or not it constitutes a fair use, and that will be the best way to explain the an infringement case relative to display rights. So that concludes going through all of the exclusive rights for the copyrighted work. Let me know if you have any questions on that. We are going to switch gears. We have one more extension of this topic. It's called the first sale doctrine. I hinted to it a couple videos ago, but they should be relatively short, discussing the first sale doctrine.